Welcome everyone to this week's Long Island Legal. My name is Joe Campolo. I'm the managing partner at Campolo, Middleton and McCormick, a full-service law firm located in Ronkonkoma, right at the Islip MacArthur Airport. And I do have some exciting news to announce about our location as well. We are expanding and opening up a second location in Bridgehampton. That office will be opening up September 1st. We'll be expanding our real estate and litigation practice out to the East End. And in a few weeks, we will have that practice group on here so everybody can learn about them. This week, I'm very excited to have with us Erin Trung. So Erin is a senior associate at the firm. She's been with us a little over 5 years now, right? Mm-hmm. And Erin has developed the intellectual property practice at our firm. And so Erin, welcome.
Thank you.
How are you today?
Very well, thank you.
Excellent. So, Erin, why don't you tell everybody a little bit about your background? You're originally a West Coast girl, correct?
Yes. So, if we want to start with the beginning of time, which is my time, I was born and raised in Silicon Valley, California. So, I'm a little techie at heart. Yeah. So, I was always interested in the technology realm. So, that was always been an interest of mine. So going to law school, I went to law school in Seattle University. I had a concentration in intellectual property, so it was really a good avenue for me to see the theoretical aspects of IP, different practice sectors, patent, trademark, copyright. And also during law school, I worked as a paralegal in some IP firms, and that also gave me some practical applications of intellectual property. So that's where I developed my interest, and after law school I was able to move on to an IP firm, and that's where I was for a few years, and I moved out to New York and met you.
That's right, I remember that meeting well.
Yes.
So tell our viewers a little bit about what intellectual property actually is, because most people don't understand how simple it is. They think it's some big secret thing that Google is creating behind lab doors. Mm-hmm. But just tell them, even for the small to mid-sized business owners, what intellectual property is.
Well, intellectual property, every business has some sort of intellectual property, some asset that they have value to, such as a name, such as a process that they have a competitive advantage over some other competitor in the marketplace. So even startups, entrepreneurs, inventors, in the very beginning, they are more focused on getting their business started, on not worrying about their assets and so forth. So, but they fail to realize they do have protectable assets that they need to focus on in the very beginning. But every business, every company has assets, intellectual property that they need to be aware of.
Right, and I guess that's part of the challenge representing small to mid-sized businesses is they don't realize that what they have might be very valuable.
Yes, correct.
And so there's also this concept of a trade secret, right? So explain a little bit about what a trade secret means, because you can file for a patent or you can file for a trademark. Those are things that you have to actually go out and file. Mm-hmm. But a lot of businesses could very well have what they call trade secrets, correct?
Yes. So it is, for example, the KFC secret recipe. It's the Coca-Cola formula, something that the company holds as essentially a competitive advantage over some other competitor in the marketplace. So it is something that the company does very well at, that they deem to be proprietary. And the good thing about trade secrets is that you don't have to tell anybody about it. You don't have to disclose it in a patent for everybody else to see, because it's something that the company keeps as a proprietary asset of theirs.
Right, so a trade secret by its nature has to be a secret, right?
Correct, yes.
So what are some of the things that business owners can do to help protect their trade secrets?
Well, in the very beginning, they have to first recognize what their trade secret is, and then implement certain policies and procedures to maintain that secret, such as employee manuals, confidentiality agreements, non-compete, non-solicitation agreements. It's certain processes that they need to implement in the business to keep that secret a secret, essentially.
Right, and that's part of it. So I know a lot of organizations feel like their client list is, proprietary and secret, but they're not automatically a secret. You have to actually keep them a secret, right?
Correct. Yes. Yes. So you have to, just now in the digital age, it's not a situation where you can lock a secret formula into a safe anymore.
Right.
Now you have to protect the system, the database, password protect certain files, making sure that that area is tightened up. So it is a matter of keeping it a secret and not letting everybody in the company know, just maybe key employees, key associates that are working at the company, and not just disclosing it to everybody.
Right, and so that's really important for the viewers to know that if they feel they have something that's, a competitive advantage or something they want to keep proprietary, they need to keep it a secret.
Yes.
And that's really important. And that's difficult, like you said, in the digital age. It's a lot difficult now, but manageable. And I'm sure that you go and help business owners understand how to keep their things secret, correct?
Yes, correct, yes.
Right.
Yeah.
So tell me a little bit about trademarks. So a lot of people don't understand trademarks. What exactly is a trademark?
Well, a trademark is a company's source identifier. So a consumer out in the marketplace looks at a mark, a symbol, a logo, and it sparks to mind the company's goodwill, company's image. It gives a certain identifier to the background company.
Right. So one of the things I've learned, and is actually from you on something, is you can use the same name as long as you're in different market spaces, right?
Mm-hmm. Yes, I'm glad you learned something from me. That's great.
I learned a lot.
Well, yes. For example, KFC is known for their chicken, their fast food chains, but somebody else can have the same rights for KFC on a technology company. So trademark rights are very goods and service specific. So when you apply for a trademark, you have to make sure that you cover all your goods, all your services, and if a company does expand into other fields, other products, you have to make sure that the trademark attorney files for the application gets those goods and services protected under that mark.
Right. And so what's the process? How long does it typically take for a company to get a trademark?
Well, typically, from filing of an application, it usually takes from 6 months to 1 year, sometimes a little longer, depending on if there's any refusals from the trademark office, any issues from any other competitor in the marketplace that files an opposition, but generally around 6 to 1 year.
And they're not very expensive to file, right?
No, not expensive at all. Their U.S. Patent and Trademark Office has a filing fee of $325 per class per mark. So it's fairly inexpensive, and it's an inexpensive fee to pay to protect the goodwill of the company.
Right. Now, one of the other things that you do on a day-to-day basis is you help some of our manufacturing clients understand what's out there in terms of patents and everything else, correct?
Yes.
So tell a little bit about that.
Yes. So we represent some inventors, some designers, and these are great egghead guys who create a product and say, oh, this is a great invention. Please see if there's any patents out there, anything that would limit my ability to go forward with the product. And that's what we do. We take a look at the product, take a look at their design, their concepts and ideas, and we do essentially a patentability search to see what's out there in the marketplace. And this really helps the person really figure out, okay, is it really worth moving forward with this product, or what should I do to tweak it a little bit so it doesn't infringe anybody else's patent.
Right. Now, a patent is for a limited time, right? I think it's for 20 years, is
Correct,
that right?
yes. 20 years for utility and 14 for design.
Right, and during that time, that company pretty much has the monopoly on
Yes,
that part,
yes,
right?
yes.
So it's a legal monopoly.
Correct.
Right. So I was always interested. I learned this as well just recently. So if you look at the policy behind patent applications, right, the policy is for people to share technology.
Yes.
But the drug manufacturers, from what I understand, there's all these knockoff drug companies that sit and wait for patents simply to expire, and the
Yes.
day they expire, they're out mass marketing Lipitor or whatever else it is that had the
Yes.
patents. Trade secrets have the opposite effect, right?
Correct.
Trade secrets keep everything secret and keep everybody guessing what's in a Big Mac and what's
Yes.
in Coke. So what happens? I infringe on somebody's patent. So you have a patent, and I make something that infringes on it. What is it? Let's talk a little bit to the business owners about even if they make a mistake, right? Sometimes people make a mistake. They use a name, they use a product that might be infringing. What's the process and what should they do? I know people get deathly afraid when they get a letter saying they've been infringing, but what's typically the process there?
Typically, I've learned that patent owners, especially the ones who are in the business, they see an infringing product out there. They just want the competitor to stop and cease and desist manufacturing of their product. But I guess if the secondary user continues to manufacture the products, does not pay attention to the cease and desist, then the patent infringement action incurs, and through that process, damages, profits are awarded to the patent holder. But typically, I found that patent holders are more interested in stopping the competitor in the market from essentially taking the patent holder's profits.
Right. But you can, if you own a patent, you can license me the right to use that product, correct?
Yes, yes.
So, and that's another area that you work with clients on.
Correct.
Also, right?
Correct.
That's good. So, final point I want to talk about a little bit is there's been a lot of changes in the IP world over the past, the past year or so. I think the Obama administration has tried to make some changes to match the global economy. What have those changes been?
So this year, the American Invents Act was implemented. Some changes were it changed the U.S. systems from a first to invent to now a first to file procedure. It puts it in par with all of the other countries that.
So the rest of the world was on whoever files the patent
Correct.
first is the one who gets the patent
Yes.
awarded, rather than having to litigate over who invented the product
Correct.
prior to filing
Yes.
it, right? It seems to cut out a lot of litigation, I suspect.
It does, and also that's where trade secrets come into play with the American Invents Act. There is a statutory time frame of if you can demonstrate that like a secondary user has been using a certain product within the year of filing the application, that secondary user can still continue to have rights to that process, even though somebody came along and filed the application first.
Right, and that sounds like something that people would need a lawyer to help them
Yes.
understand and
Yes.
establish, right?
Yes, and definitely you do need to establish procedures, policies in order to protect trade secrets, and making sure that if push comes to shove, something happens and you have a cease and desist letter on your hands, that you already had the steps to protect that trade secrets, and the courts will look at your product as a trade secret.
Right. So folks, I guess the takeaways from this week's episode, and thanks Erin, because intellectual property is a very complicated area to understand, but the takeaways for business owners to understand are, very much so, things that you have could be considered intellectual property. They don't have to be created in a secret lab behind a secret vault. They could be very simple things that give you a competitive advantage.
Yes.
And you can either protect those with a trademark or a patent, or if that relief is not available for you, you can protect them by having them become a trade secret, right? And all of those things are what you and your daily practice work on with our clients. So anybody out there who does need to understand more information about this and this complicated area. Erin is very good at simplifying those issues for our clients. And so thanks, Erin. We appreciate you being here today.
Thank you.
And thanks, everyone. Again, we're Campolo, Middleton, and McCormick, a full-service law firm at www.cmmllp.com.